your conference name.
Stensrud.
Yeah.
We've come to the eighth and final presentation of the day. Yesterday you heard about the Jahre-case and how that money was retrieved. We have a similar story here in Norway, the Jahre-case, where the large fortune of a Norwegian businessman was left offshore, and it took almost 30 years to retrieve that money. The sum that was eventually returned to Norway was about 1 billion Norwegian kroners. And we will hear more about this story from one of the lawyers who was central in retrieving the money. Mr. Karstein Espelid is a partner at the Norwegian law firm BAR. He is originally from Bergen, but now lives in Oslo and works at the headquarters of BAR in Oslo. He is a former prosecutor and deputy judge, and together with his colleague Even Var Hansen, Espelid was appointed to manage the Anders Jahre estate. And just recently finished that very, very long process of retrieving a very large amount of money. And we'll hear more about the story from Mr. Espelid now.
Thank you very much. Thank you for being invited here. My talk is about the Jahre-case. And the Jahre-case, what is it all about? Three main issues: hidden assets, locate the assets, repatriate them. Very clear and easy goals, but very, very difficult to achieve, and not to forget, involving enormous costs. As Mr. Rønneberg already told you, my name is Karstein Espelid. I'm born and raised in Bergen, but I do live in Oslo. And as we all have experienced the Bergen weather over the last days, you do understand why. And I am, as also told you by Mr. Rønneberg, a partner of the law firm BAR in Oslo. And this is our new building. The architect is Mr. Piano, worldwide known. But this has nothing to do with the Jahre-case, except for some money I placed there through our bonuses. This is the content. And I start now at the beginning of my speech, the introduction. BAR, the law firm I'm a partner of, is perhaps best known as a commercial law firm, but has considerable experience in dealing with litigation, restructuring, and insolvency matters. Before the Jahre estate, we were, for instance, involved in the estate of another famous Norwegian ship owner, Hilmar Reksten, who operated out of Bergen. And a short story from the Reksten case, which I also litigated, is that took place in Bergen, partly, and I had to go to a shoe repair with my shoes. And when he saw me, he said, "No, Mr. Espelid, you can't call for any services by me." So that is a sign of the local patriotism in Bergen. While the estate of Anders Jahre has been under public administration since shortly after his death in 1982, we, BAR, have only acted as administrators since 1991. That is to say, for more than 20 years. In connection with the recent winding up of the estate, a comprehensive report from the administrators have been made publicly available in Norwegian only, and you will find it on BAR's homepage. The purpose of my speech today is to address some of the challenges we were faced with on behalf of the estate in our quest to bring Anders Jahre's foreign fortune back to Norway. As a background, I will first say a few words about Anders Jahre and how his foreign fortune was built up and concealed. This is a picture of Mr. Jahre, highly decorated, as you can see. Anders Jahre was born in 1891 in Sandefjord, Norway, where he lived and worked until his death in 1982. Anders Jahre, mind you, practiced as a lawyer in his hometown until 1928. But already in the early 1920s, he began to engage himself in the whaling and shipping industries. He invested in many whaling and shipping companies and personally formed several companies to conduct various administrative and operating functions. The most important company associated with Jahre was Cosmos. That's a clean entity. An entity operating out of Sandefjord and managed by the firm of Anders Jahre. In addition to being a successful businessman, Anders Jahre made contributions to society, inter alia by forming several foundations for the promotion of scientific and humanitarian objectives. He was regarded a major philanthropist and was honored with the Royal Norwegian Order of St. Olav in 1950 and 1962, as well as an honorary professorship at the University of Oslo in 1961. So, as you can imagine, Anders Jahre was a highly respected shipping and industry magnate, both in his hometown of Sandefjord and within the Norwegian society at large. There is, however, another side to the picture, namely Anders Jahre's hidden funds overseas, his foreign fortune. And that leads me to my position here. The solvent estate of Anders Jahre deceased, the estate. Investigations by the tax authorities that had been initiated before Anders Jahre's death in 1982 resulted in a tax claim being levied against his estate in 1983 in an amount of in excess of 335 million Norwegian kroner, the largest tax claim that had ever been assessed in Norway for tax avoidance. The estate was thereafter treated as an insolvent estate, its liabilities exceeding its assets. The main creditors of the estate are the municipality of Sandefjord and the Norwegian government, represented by the tax collector in Sandefjord. After Anders Jahre's death, the administrator of Jahre's estate came into possession of documents that confirmed Jahre's unlimited control over a period of more than 40 years to conceal that control from the authorities. And the unlimited control was over foreign assets. Such control has subsequently been confirmed by two Norwegian judgments in 2002 and 2003. Thus, he was regarded as the true beneficial owner of the assets in question. At the time of Jahre's death in 1982, the value of the assets remaining in his foreign fortune totaled some $80 million. There is no other known instance in Norway of tax avoidance on such a large scale over such an extended period. A few words about the background to the Jahre-case, and then I'm going into the foreign fortune as such. In his lifetime, Anders Jahre built up and managed a considerable fortune outside Norway via companies registered in Panama and elsewhere. In 1939, Panko's operating company SA was incorporated as a Panamanian corporation. Throughout his lifetime, Anders Jahre consistently maintained that he had no ownership interest in Pankos. Only after his death was it established that Jahre had controlled this company from the day it was incorporated, and that from the 1950s onward he had been its sole owner. During the 1950s, the Norwegian authorities commenced an investigation of Jahre's connections to Pankos and other foreign companies. In response, and in order to conceal his ownership interest, Jahre claimed that these companies were owned by Aristotle Onassis. The investigation was put on hold when Jahre suggested that it might be possible for Norwegian companies controlled by Jahre to purchase Pankos et al.'s floating assets from Onassis at market price. Such ships would in that manner become Norwegian flagged vessels, which at the time was considered an important objective by Norwegian authorities. This had to do with currency situation in Norway. This solution was accepted, and as a result, large sums were transferred abroad to companies ostensibly owned by Onassis. The net result of the transaction, however, was that the cash generated by the sale of ships was consolidated with Pankos' other assets and became a major part of Jahre's hidden fortune, foreign fortune, a fortune that grew substantially in the years thereafter. To conceal his connection with Pankos, Jahre secretly changed the name of the company in 1958 to Continental Trust Company (CTC). Pankos' minutes, as you can see here, of the extraordinary general meeting in 1958, at which the renaming of the company was resolved, demonstrate Anders Jahre's full control over Pankos CTC. And you can read it by yourself. Mind you, that it states that all shares were represented. Well, I can tell you there were hardly any shares issued. So this is the way they fabricated the renaming and set it in for registration. Pankos was known to the authorities, the name. CTC was unknown. But CTC continued business was conducted quietly, however. And it was only after Anders Jahre in 1972, on behalf of CTC, promised the Sandefjord municipality a 40 million Norwegian krone donation for the building of a new town hall, that Anders Jahre's foreign interest again attracted the attention of the authorities. The town hall donation to the Sandefjord municipality generated lengthy correspondence between Norges Bank. Norges Bank is the equivalent of the Norwegian Central Bank, and Anders Jahre. Starting with the question whether Norges Bank would issue a foreign exchange license for transfers to the Sandefjord municipality from CTC's account in Sweden. Anders Jahre categorically denied having any ownership interest in CTC. After 1972, the Norwegian authorities' interest in Anders Jahre's relations with CTC showed no signs of abatement. It gradually became clear to Anders Jahre and his helpers that the focus on his foreign fortune would make it difficult for him to repatriate it to Norway in the short term. Efforts were therefore commenced to reorganize the ownership of CTC in order to create a formal structure whereby Anders Jahre could retain control of the funds abroad without appearing to have any involvement in the company. With help of Bjørn Bettum, who by then played a leading role of Cosmos and the firm of Anders Jahre, and Lassard Bank London, an ostensibly charitable trust was formed in 1976 under Bahamian law, later Cayman Island law, under the name of Continental Foundation, to act as the formal owner of the shares of CTC. Since Anders Jahre could not appear as the settlor of the trust, as this would reveal his ownership interest in CTC, the Norwegian in exile, Torleif Monsen, was appointed as the nominal settlor. Continental Foundation was organized so that no single person could acquire control over it or its funds. Formal control being exercised jointly by the appointed advisors. This is in accordance with the structure of trusts in Cayman and Bahamas. And the appointed advisors were Torleif Monsen, the in exile Norwegian, Hugo Kindersee from Lassard Bank, and a third person connected to Lassard Bank. In addition, Lassard Bank had a central supervising and controlling function for the purpose of safeguarding compliance with Anders Jahre's intentions and interests. Bjørn Bettum, Mr. Jahre's right-hand man, was instrumental in the establishment of the trust, but did not personally have any formal position in it. Sorry, I moved too fast there. Some words about the state's legal actions, jurisdictional obstacles. The whole estate has been full of litigation. I don't know how many court instances I've been through, but it's a number of them. Many, too many. And this is a result of the fact that the estate has brought a number of legal proceedings in order to recover assets. The cases have involved the following jurisdictions, mainly Norway, UK, the Cayman Islands, and the US. Matters involving parties from around the world are almost bound to cause jurisdictional complications. The Jahre-case is no exception. In 1994, that is to say 3 years after we were appointed, the estate brought a claim against 82 persons and companies before the Chancery Division of High Court in London, UK. Several of the defendants did not have legal venue in London, but were included due to their connections with the events and certain central London-based defendants. The choice of London as venue was also desirable from the estate's perspective due to the renowned competence of British courts and their highly skilled and respected judges. Objections to the court's jurisdiction were raised, and a preliminary hearing in London for the purpose of determining jurisdictions was scheduled to take place in 1995. In the meantime, the estate was sued in the Cayman Islands by certain parties related to some of the defendants in the UK proceedings. The estate saw this as a counter-move to the proceedings in UK, and therefore moved for a stay in the Cayman Islands proceedings, pending the outcome of the UK proceedings. The estate was unsuccessful, and as the Cayman court began to deal with the merits of the case, while the estate's appeal with regard to jurisdiction was still pending, well, the estate was left with no choice to renounce its objections. Subsequently, the estate even withdrew its action from the UK court in order to fully focus on the Cayman Islands proceedings. It is fair to assume that the Cayman Islands proceedings were initiated by the estate's opponents, largely on the assumption that the Cayman Island court would look more favourably at the arrangements the estate was challenging than the UK court. If so, the plaintiffs were not disappointed by the court of first instance, the Grand Court of Cayman Islands, situated in Georgetown. In the estate's experience, the court was dragging its feet. Furthermore, and mind you, the court approved the use of trust funds to finance the defense against the estate. Conversely, the estate was obliged to finance the costly litigation from the estate's own funds. However, subsequent judgments by the Court of Appeal and the Privy Council is the answer to House of Lords within the Commonwealth, constituted by 5 judges, 3 of them recruited from House of Lords and 2 from the various islands in the Caribbean. It was judgments subsequently from the Court of Appeal and the Privy Council. They were both in favour of the estate. Those 2 judgments confirmed the estate's view that Continental Foundation was not a validly established trust. These judgments altered the entire attitude of the Grand Cayman Court towards the estate. So although the Cayman Islands judicial system eventually stood the test, one can easily imagine that jurisdictional matters may have great impact on the possibility of fighting economic crime. Some words about the results and the recoveries and the funding. Through settlement agreements and judgments, the estate has recovered in total, including interest, 1,060 million Norwegian kroner. The net assets for distribution to the estate's creditors are some 420 million Norwegian kroner. This shows that the costs have been formidable, amounting in total to 600 million Norwegian kroner, plus a 40 million Norwegian kroner profit sharing with a third party. So, what does this tell us? Asset tracing through cross-border litigation is extremely expensive. In practice, only states or solid group of companies will be able to raise and risk the funds required. The portion of the Jahre estate, the assets, that was easily available to the estate was relatively limited in size. When the estate brought legal proceedings in the UK in 1994, much such assets, around 40 million Norwegian kroner, had been spent, and the estate was dependent on third-party financing to pursue its interests in the courts. Attempts were made to obtain private financing, but no responsible institution was willing to take the risk involved in such a project where the outcome could easily be zero. In light of the fact that the main creditor was the tax creditor, the Norwegian government proposed provision of a guarantee of up to 100 million Norwegian kroner in order to cover expenses and any liability in connection with the administration of the estate. This proposal was opposed by the right-wing Norwegian Progress Party, Fremskrittspartiet, but was ultimately approved by the Norwegian Parliament, Stortinget. The initial guarantee was increased in 1998 over the opposition of both the Norwegian Conservative parties, Fremskrittspartiet and Høyre, by an additional contribution of 50 million Norwegian kroner, that is to say, in total 150 million Norwegian kroner plus interest. throughout the period when the original guarantee and later its increase was under Parliament's consideration. Both Bjørn Bettum and Anders Jahre's Humanitarian Fund had actively opposed state financing of the estate activities, often in coordination with conservative elements in Parliament. The guarantee financing was nonetheless approved, the majority in Parliament being motivated, in part, by a desire, a clear message, to send a clear message that those involved in tax avoidance would be pursued no matter the cost. From 1994 and up to January 2002, the estate's accumulated expenses, including interest, under the guarantee amounted to 176 million Norwegian kroner. That amount was repaid to the state in January 2002. Excuse me. In summary, without state financing, it can safely be stated that the estate would not have been in a financial position to trace assets and bring lawsuits in various jurisdictions to recover and repatriate the foreign fortune. We were absolutely dependent on the guarantee from the government and supported by the majority of the Parliament. I will now deal with some secrecy aspects, since that is the heart of today's issue. We haven't been touching upon the banker confidentiality, but that's one important one. And I'll start out with that, because that was a major hurdle which we had to pass. And which we passed, but not without complications, and not without involving the courts. I start out with the case against Lassad et al., banker confidentiality. When Anders Jahre died, the foreign fortune was not made available to the estate. Shortly after his death, the acting administrator of the estate contacted Lassad Bank, among others, seeking information regarding CTC's assets and Jahre's other holdings. In response to specific inquiries, however, Lassad withheld essential information and failed to provide the information necessary to repatriate the foreign fortune. In doing so, Lassad misled the estate and gave the impression that Jahre did not own CTC. A key issue at the time of Jahre's death and in the years immediately thereafter was whether Lassad was prohibited by a contractual duty of confidentiality from providing the requested information to the estate, where such information had been obtained by Lassad in the course of providing banking and related services to Jahre and or CTC. In England and most countries, there is a general principle that bank owns a duty of confidentiality to keep its customers' affairs secret. Not surprisingly, that's common. It may not divulge such confidential information to any person other than the customer. And Lassad relied upon this privilege. During the legal proceedings in Norway, the estate alleged that under Norwegian law, the administrator, we, were walking in the legal shoes of Mr. Jahre, and that Lassad was therefore under an obligation to make disclosure of what it knew concerning Jahre's hidden foreign assets. Lassad disagreed and maintained its position for many years after Jahre's death that it was unable to provide the requested information. During the legal proceedings in Norway between the estate and Lassad et al. In the late 1990s, the bank was to a large extent compelled by the court to produce the documents and information as requested by the estate. It had taken some 15 to 20 years after Jahre's death, however, before the estate, through court compulsion, finally obtained the documents and information it had been seeking all along, and which pointed to the assets' locations. We have heard several of the speakers talking about trusts. Trust is a very complicated concept, in particular seen with Norwegian glasses. It has nothing to do with the Norwegian Stiftelse, which is a separate entity regulated under Norwegian law. But trusts are very common in England, in Commonwealth, and in all of the jurisdictions down in Caribbean, and not to forget in Liechtenstein, where they also have anstalts and fondation, and in Switzerland too. But now I'm talking about trust, insight into trust domiciled mainly in Cayman Islands and many of the tax havens in the Caribbean. For those seeking to place assets beyond the reach of creditors, offshore asset protection trusts offer secrecy and freedom from taxation, while preserving the trust set laws absolute control over trust assets. Jahre's Continental Foundation was an example of this type of trust. By way of example, the formalities for creating a trust in Cayman Islands could hardly be easier. There are 3 essentials. Find a trustee, agree the terms of the trust, and transfer the property to the trustee. In the usual case, the terms of the trust will be set out in a document signed by the set law and the trustee, called the trust deed or the memorandum of agreement. The creation of a Cayman trust is ordinarily a private transaction involving no filing of documents or information with any government authority. So you need the document at hand to see that there is a trust, who contributed to the trust, the name of the set law, and so on. There's no registry. Furthermore, in general, there are no taxes or government charges on the creation or funding of a trust or on its operations and distribution. But there is a stamp duty of USD 50 to be paid on every trust instrument. That has to do with the validity side of the document. But indirectly, this is another way of securing income for the financial department in each island down there. It is often decided that this trust structure should include one or more holding or investment companies. In other words, the assets of the trust may often comprise shares in a holding company, with the actual assets, the cash, the real estate or other investments, being held directly or indirectly by the holding company rather than the trust itself. Thus, upon establishment of Continental Foundation in 1976, it was bearer shares, you know that, I hendeavaksjer in Norwegian, bearer shares in CTC rather than assets of CTC, which were settled upon the trust. So CTC continued its corporate activities as before, but with the trust rather than Jahre appearing as owner of CTC bearer shares. To be more precise, this structure was intended to eliminate speculation that Jahre was the owner of those bearer shares, and was one of the devices used by Jahre and his associates to place the CTC assets beyond the reach of Norwegian tax authorities. Mr. Reeves talked a lot about various legal entities in the tax havens around the world, and I can point to one just to illustrate. Sorry? 2 minutes left. 2 minutes left. Give me 5. Or 7. He took 5 from me and you had 5. That gives me 10. Use of exempted company in Cayman Islands. The Cayman Islands and many other tax havens authorize the creation of various forms of corporate entity. One such form is the exempted company, which is very often used by those seeking to maintain secrecy with respect to the entity's true principles and purposes. Notable features of a Cayman exempted company include, and you can read it by yourself, a tax-free status for 20 years, good to have in your pocket, issuing shares in bearer form, securing absolutely anonymity. And mind you, keeping its register members anywhere in the world, with the register not available to public inspection. No requirement to hold an annual general meeting of shareholders, nor to file shareholders' information, and so on. It may not engage in business in the Cayman Islands, but it may conduct operations from the Cayman Islands. And what does this result in? If you do search for this company, you do have the name by hand. The search of the company registry will only reveal the date of incorporation, the type of company, namely exempt, and where the registered office is situated. That's it. Finally, no information treatment can repair that lack of information. You have to change the internal rules. In summary, those forming an exempted company can keep secret both the entities of the corporate owners and its financial activities. Moreover, the company can be operated tax-free so long as a nominal annual fee is paid to the local government. Perhaps not surprisingly, when the estate inquiries with regard to the foreign fortune began to focus on the Cayman Islands and the activities of the Norwegian expatriate Torleif Monsen in connection with the CTC assets, the estates found that various entities involved in the holding of administration of assets derived from CTC were Cayman exempt companies. Not only were efforts to investigate the actual ownership and purpose of these companies time-consuming and expensive for the estate, but Cayman law actually made it a criminal offence for any person to divulge the kind of evidence the estate was seeking. And I'm moving on to this because this is very interesting, and it follows up what Mr. Reeves talked about, namely it's a criminal offence to give information. And that has to do with the Confidential Relationship Preservation Law in Cayman Islands, also called CRIPL. The disclosure of confidential information in the Cayman Islands arising in a professional relationship is governed by Cayman Islands CRIPL. CRIPL was introduced only to maintain the secrecy of business activities and is, mind you, of extraterritorial effect. Its provisions defined confidential information to include a broad range of commercial information and set forth the circumstances in which such information may or may not be disclosed. CRIPL makes it a criminal offence to disclose such confidential information or deliberately to obtain it or attempt to do so except in certain specified circumstances. The law applies not only to bankers but also to all professional persons. I forgot this. Confidential information includes information concerning any property which the recipient is not authorized by the principal, i.e. the client or customer, to divulge. A professional person is widely defined and includes banks, trust companies, attorneys at law, accountants and insurers, among others. Subject to some exceptions, CRIPL has application to all information with respect to business or of a professional nature, which arises in or is brought into the Cayman Islands, and to all persons coming into possession of such information, whether they be within or even without the jurisdiction. And that they tried to give this application to us, and I come to that. I think this is interesting. The estate was approached by a third party who handed over information to assist the pursuit of the foreign fortune. There were potential difficulties with this. For example, trust law. Are the relationship between trustee, settlor and beneficiary professional relationships? The relationships between a company, its shareholders and its directors, are those professional relationships? Information which has been imparted to a professional, which may not itself be considered confidential, since it is readily known by another non-professional. Does the existence of the professional relationship mean that CRIPL is nevertheless engaged? Those in control of what remained the foreign fortune knew that the estate had acquired information from the third party I just mentioned. Predictably, they contended through the litigation that the estate had acted in breach of CRIPL. It could not rely on any of the information. Worse, it could not bring any action at all because it was irredeemably tainted by breaches of CRIPL. And yet worse, its representatives, me, were under threat of criminal prosecution and imprisonment. In the case, the estate was ready to argue that there had been no breach of CRIPL at all. Even if there had been, the estate did not rely on any information which had been provided in breach of CRIPL. It could mount its case without it and without any abuse of the Cayman courts. The estate remained free to rely on such information in any event, since there was no confidence in iniquity. The arguments as to the breach of CRIPL were never tested in court. The experience still demonstrates that CRIPL is a powerful tool that one can expect will be used for all its worth as a defense against those tracing assets. And some closing remarks, very few. What is this? This is the Jahre-case in a nutshell regarding secrecy issues. However, I've only been able to touch the top of the iceberg. Still, I hope the case serves to illustrate some of the practical difficulties one may be faced with when tracing assets across jurisdictions. Thank you for your attention.